everyone. Welcome to Crime in Court. This is the Commonwealth versus Karen Reed Trial 2.0. And we have been going through the flood of the motions in limine that have just recently come from both the Commonwealth and the defense. We are on episode 125, Motions in Limine, AARCA's Lack of Bias. So, as you can tell by the title, it has something to do with the AARCA experts. Obviously, they were not hired by neither the Commonwealth nor the defense, and the defense believes that it is prejudicial to not allow the jurors to know that they are a non biased party. And so that information should be available to the jurors. It was not clear, as we know now after trial with interviews of the jurors, they did not understand that ARCA was actually paid for by the FBI. They thought it was insurance, or they thought somebody like a Turtle Boy. So they didn't know who Turtle Boy was, but somebody had suggested that Turtle Boy had hired them. So, anywho, so that kind of that's prejudicial to Karen because they are definitely not biased. They're impartial third party expert witnesses who testified to the fact that Karen's car did not hit John's body. John's injuries on his body did not come from a car. So unequivocally, Karen Reed did not do it, according to the ARCA experts. So Karen's defense team has filed a motion in limine to allow evidence of the lack of bias, and we also have an affidavit. So we're going to go through those in this episode. So please hit that like button and let's begin. All right, so the defendant's motion in limine to allow evidence of lack of bias. Now comes the defendant, Karen Reed, and respectfully moves this honorable court in limine to allow during her retrial reference to the fact that it was the U.S. Attorney's Office that initially hired employees of ARCA. So last time, trial one, they were not allowed to say that the feds hired the ARCA experts. They are asking explicitly for information or for permission from the judge to be able to say that they came from the U.S. Attorney's Office. Namely, their witnesses, Daniel Wolf and Andrew Rentschler, and not the defense who commissioned these witnesses. It was not the defense who commissioned these witnesses to perform testing and analysis of evidence relevant to this matter. As grounds, therefore, Ms. Reed states that their retention by the U.S. Attorney's Office and not by the defense bears directly on their credibility, rebuts any contention by the Commonwealth of bias, which they've been trying to pull, and will avoid causing the jury to unfairly speculate about the origins of their involvement or otherwise prejudice Ms. Reed's constitutional right to due process and to a fair trial. And that is according to the U.S. Constitution and the Massachusetts Declaration of Rights. We had a footnote here that says Ms. Reed wishes to clarify herein in light of information sought by the court during recent motion hearings and disclosed by the defense's reciprocal discovery that the defense was invoiced by and did pay ARCA only following the conclusion of the first trial. The defense intends to comply with its reciprocal discovery obligations pursuant to Mass Art. Crim. P. 14 regarding ARCA's participation in the retrial, including its continuing duty to disclose under Mass Art. Crim. P. 14 should it acquire any additional discoverable information following the March 6th reciprocal discovery deadline. Factual background. On day 31 of Ms. Reed's first trial, June 24, 2024, both Daniel Wolf, PhD, and Andrew Rentschler, PhD, testified. Both Dr. Wolf and Dr. Rentschler stated that they were neither hired by the defense nor the Commonwealth. In fact, these two employees of ARCA explicitly articulated that they did not have contact with the defense or the Commonwealth regarding the specifics of their testing, did not consult with the defense or the Commonwealth, and Dr. Wolf himself clearly noted that ARCA employees were hired by another agency not connected in any way to the defense. But it still wasn't clear to the jurors. The particular agency was left for the jury to speculate about. Right. And at least one member did. The independence of these ARCA employees, specifically Daniel Wolf, PhD, and Andrew Rentschler, PhD, was reaffirmed during motion hearing ahead of Ms. Reed's second trial. And they're asking you to see the transcript. All right, so nevertheless, these individuals who will serve as two of Ms. Reed's most critical exculpatory witnesses were indisputably engaged and hired by the United States Attorney's Office to conduct their independent review, analysis, and testing surrounding the singular question of whether Mr. John O'Keefe died as a result of an auto pedestrian collision with Ms. Reed's SUV. These highly qualified experts have determined to a reasonable degree of scientific certainty that 1. Mr. O'Keefe's injuries and death did not result from being struck by Ms. Reed's SUV, and 2. The damage to Ms. Reed's SUV did not result from the colliding with Mr. O'Keefe. In other words, the scientific data establishes that Ms. Reed did not strike Mr. O'Keefe with her vehicle. Both Dr. Wolf and Dr. Rentschler, two individuals who were not hired by the defense to perform their testing, testified to this highly relevant and exculpatory fact during Ms. Reed's first trial and during their voir dire that they had to come out, and that was what Karen actually had to pay for was the voir dire and all of their housing and things. And they testified to that under oath and the threat of perjury. Furthermore, the Commonwealth, by its own admission, has admitted that it's not the ARCA witness that I have the issue with. That was straight from Hank the horse's mouth. He said he doesn't have a problem with the ARCA witnesses. Moreover, the Commonwealth stated that it doesn't care if the ARCA witnesses testify at trial. I don't care about their opinions. I'd welcome ARCA. Foot in mouth, Hank Brennan. Most recently, the Commonwealth communicated to this honorable court on February 25, 2025, that there is a murky relationship between the defense and the United States Attorney's Office relative to these ARCA witnesses, and there is a very unclear relationship as we stand right here, right now. This is coming from Hank. Between the history of the interaction between the defense and the ARCA witnesses. They try to make it seem like there's some kind of nefarious something or something going on with either the defense and the ARCA witnesses or the defense and the U.S. Attorney's Office, which is just ridiculous, but okay. The Commonwealth has additionally conceded that we still don't know the relationship between the defense and ARCA. We don't know about the impact it has on the first trial. The Commonwealth has provided no objection or legitimate legal basis for not disclosing in Ms. Reed's second trial that employees of ARCA were hired by the U.S. Attorney's Office. So he doesn't care. He welcomes them, in fact. And for that, you should allow the defense to be able to say, hey, the FBI hired these guys. So in fact, the Commonwealth the Commonwealth itself, or the feds, I should say, not necessarily the FBI, but the feds. In fact, the Commonwealth itself has articulated that there is a lack of clarity about key information pertaining to these potential witnesses. If the Commonwealth, who has been privy to the relevant discovery for months and has had an opportunity to question these witnesses during voir dire in Ms. Reed's first trial, has expressed confusion about the nature of the relationship between ARCA and the defense, then it is only logical that the jury too might be confused by the nature of ARCA's involvement without a full and complete understanding of how, why, and by whom these individuals were hired. And you can't leave it to Hank to muddy up the waters and make it seem like, Karen and ARCA are like somehow conspiring against the McAlberts. Like, really? Crazy. All right, so the argument here is to avoid unfairly prejudicial speculation, this court should admit the fact that the U.S. Attorney's Office hired and retained employees of ARCA. Proof of bias, or lack thereof, directly bears on the credibility of a witness. It is never collateral in nature and extrinsic evidence to prove it is permitted. In criminal cases, the defendant's right to confrontation provides a constitutional basis for admissibility. Indeed, a criminal defendant has a constitutional right to show bias. If the defendant demonstrates that there is a possibility of bias, even a remote one, the judge has no discretion to bar all inquiry into the subject. Bias is the relationship between a party and a witness which might lead the witness to slant unconsciously or otherwise his testimony in favor of or against the party. Bias may be induced by a witness by a witness's likes, dislikes, or fear of a party, or by the witness's self interest. Proof of bias is almost always relevant because the jury, a finder of fact and weigher of credibility, has historically been has been entitled to assess. Oh my God. Let me read that again. Proof of bias is almost always relevant because the jury, as finder of fact and weigher of credibility, has historically been entitled to assess all evidence which might bear on the accuracy and truth of a witness's testimony. So it's the jury who's supposed to determine that, and bias is relevant in this case. I don't know. So during the first trial, so bias or lack of bias is relevant, is what they're trying to say, because it helps the jury, who is the weigher of credibility, it helps them determine credibility of witnesses. During the first trial of this matter, the defense was prohibited from mentioning the federal investigation into the investigation of the case. The prohibition extended, however, to the fact that the Department of Justice retained ARCA completely controlled the material that they were to review and the testing they were to perform. To the extent that the Commonwealth impeached these witnesses by pointing out the material they did not review prior to performing their testing and forming their conclusions, the Commonwealth left the impression that the defense improperly withheld certain materials. Exactly. They made it seem like the defense did something wrong, that the defense improperly withheld certain materials from those witnesses. That was a false impression and prejudiced Ms. Reed's defense by keeping relevant rehabilitation and credibility evidence from the jury. So if they were able, by not being able to discuss the federal investigation or the fact that ARCA was hired by the feds, it totally prejudiced Karen Reed. All right, so worse, the inability of the defense to reveal and/or explain ARCA's initial involvement in this matter led to jury confusion and also prejudiced Ms. Reed. Post-trial jurors contacted the parties and/or made statements in public about the jury's views of ARCA's involvement. At least one member of the jury surmised that ARCA must have been retained by Ms. Reed's insurance company. So there you go. One jury member said an insurance company hired him and or them, and that is not the case. That assumption would lead to an inference of bias in favor of Ms. Reed, making it seem like she's the one, Ms. Reed is the one whose insurance company investigated this. So no big deal. They would have done it because it's a car accident or something. Like some people might think that way, which that's not even the case. So at least one other member of the jury speculated that the ARCA witnesses were seeking to insert themselves into the case for fame or publicity. Interesting. That assumption would lead to an inference that their testimony should be unfairly discounted. Importantly, identifying explicitly that neither the defense nor an affiliated third party initially hired these ARCA employees is not only crucial to Ms. Reed's case, but is also relevant evidence that is inherently admissible. It is also entirely true, as is the fact that the conclusions of the ARCA witnesses were made before either party was even aware of the existence of the witnesses in any matter pertaining to Ms. Reed. So before they even knew each other, basically. Well, I mean, ARCA knew who Karen Reed was, but she didn't know who ARCA was. They were investigating her and her car and if she could have done it before they even knew who she was. So she couldn't have influenced them. Additionally, there was no permissible grounds under the Massachusetts Rules of Evidence to exclude such relevant and exculpatory evidence, particularly in response to any hypothetical and/or unsubstantiated concerns that unfair prejudice and misleading the jury would occur by presenting such evidence. In fact, presenting to the jury that employees of ARCA were initially hired by the U.S. Attorney's Office would serve to prevent juror confusion. No shit. But because Bev loves to confuse the jurors on the actual evidence, that's why she allowed it last time. And I think, I hope they didn't real. I don't remember. I have to go back and look at like the pretrial hearing and records. I know they wanted to bring in the federal investigation in the beginning, in the first trial, and it was ruled against. But I can't remember why. If anybody remembers, please let me know in the chat, or the comments below. Um, I can't remember why she denied it. But I don't think they had as strong of an argument now because now they have jurors that said it confused us. We thought it was something else. So now their argument to keep this to allow them to mention the federal investigation and the feds hiring ARCA is going to prevent confusion and I don't know. I really hope that she allows this, but let's see what happens here. Indeed, excluding such relevant and exculpatory evidence would mislead the jury. The trier of fact, in this case the jury, is entitled to hear relevant evidence, particularly that which makes a fact more or less probable than it would be without the evidence, and where such fact is of consequence in determining the action. Knowing that employees of ARCA were not hired by the defense or Commonwealth and instead were hired at the time that they performed their testing by a neutral third party can and should add legitimacy to the credibility of the individual's testimony, as the potential for bias or any other self serving reasons for the defense calling of said witnesses would thereby be eliminated. The Commonwealth, of course, is more than welcome to cross-examine these witnesses regarding its allegations of bias or favoritism, noting that cross-examination of a witness to demonstrate his bias or interest is a matter of right. So we're not saying you can't talk about, bias or anything like that, but go ahead. Go right ahead because there isn't any, and we encourage it. Go for it. As long as we get to talk about the feds and the fact that they were hired by the feds. I think that's important. It's counterbalancing, I mean, they both should be fairly able to ask questions on how they were hired. This information about the hiring of ARCA employees, furthermore, could help the jury better evaluate the defense's theory of the case that Ms. Reed could not have been and was not responsible for the death of Mr. O'Keefe, essentially by clarifying who initially identified, hired, retained, and directed the investigation and testing performed by the employees of ARCA, Ms. Reed should be allowed to substantiate her lack of culpability by presenting evidence that an impartial third party vis-a-vis their findings corroborates her defense. In short, for the jury to properly weigh the credibility and accuracy of the ARCA employee's testimony, it must know the full context in which these potential witnesses were brought in to opine on this matter. For these reasons, it is imperative that the jury in this retrial is made aware that the employees of ARCA were initially hired by the U.S. Attorney's Office, eliminating any possibility that the jury believes that Ms. Reed or any related affiliates were the impetus of ARCA's testing and analysis. We don't want the jurors to believe that Karen Reed or any of her affiliates had anything to do with hiring her because they didn't. Throughout this motion, the defense is referring to the initial retention of ARCA by the Department of Justice for the purpose of conducting its testing, analysis, and producing a report. The defense again acknowledges that ARCA was paid after the conclusion of the first trial, as the defense disclosed in its reciprocal discovery production and as was discussed extensively during motion hearing before this court on 218 and 225 and 3-5 of this year. So 3 different hearings they talked about it. Next point is the fact that the U.S. Attorney's Office hired and retained employees of ARCA is relevant admissible evidence. It is undisputed and relevant evidence that the U.S. Attorney's Office hired and was responsible for involving employees of ARCA in an investigation surrounding Mr. O'Keefe's death. This pertinent information that a neutral federal investigative body, as opposed to the defense or an affiliated third party, retained ARCA is clearly relevant and, beyond being relevant, is exculpatory evidence that is fundamental to Ms. Reed's case. So not only is it neutral, that's not what I meant to highlight. Not only is it relevant, it should be admissible, but on top of that, it's exculpatory. So by keeping it out, you're somehow, you're debilitating Karen's defense, which is exactly what they're trying to do. According to Massachusetts precedent, all relevant evidence is admissible unless barred by an exculpatory rule. Blah, I cannot talk today. I'm sorry. Additionally, the Massachusetts Supreme Judicial Court has long recognized that as a general proposition, a judge does not have discretion to exclude relevant evidence. So it's relevant evidence, and judge does not have any reason to exclude it. The general rule is to be followed in this Commonwealth is that all relevant evidence is admissible unless within an exculpatory rule. We are influenced by the general view that relevant evidence should be admitted unless there is a quite satisfactory reason for excluding it. Relevant evidence may only be excluded if this honorable court finds that the evidence's probative value is substantially outweighed by a danger of one or more of the following: unfair prejudice, confusing the issues, misleading the jury, undue delay, wasting time, or needlessly presenting cumulative evidence. Acknowledging the objective fact that employees of ARCA were hired by the U.S. Attorney's Office is relevant, probative, and would not confuse issues, mislead the jury, or otherwise cause an undue delay, waste time, or constitute cumulative evidence. More pertinent to the arrow issue presented in this motion, the probative value of the evidence is certainly not substantially outweighed by any of the above. I loved this paragraph. This really laid out you can only exclude things based on these reasons here. Unfair prejudice, confusing the issues, misleading the jury, It's not doing any of these things. So bringing this evidence in that the employees were hired by the U.S. Attorney's Office does not do any of these things. So therefore, you cannot exclude this. So the fact that she excluded it in the first trial to begin with is insane to me. I don't know how she, like, what her basis was for that. I still don't understand. I have to go back and look at all of it to refresh my memory. It's been over a year ago, geez, or been a year almost. All right. Relevant evidence. We are 20 days away from the Karen Reed trial 2.0, by the way. Just letting you know, 20 days away. Not a lot of time to get this stuff done. All right. So, relevant evidence by nature is inherently somewhat prejudicial. That is why it is offered. The rules of evidence have contemplated this fact and bar admission of evidence only if its probative value is substantially outweighed by its risk of unfair prejudice. The measure of unfair prejudice is not whether the evidence simply is adverse to the party against whom it is offered. To find that evidence is unfairly prejudicial and thus inadmissible, generally the evidence must influence the jury to decide the case on an improper basis. More specifically, evidence is unfairly prejudicial if it appeals to the jury's sympathies, arouses their sense of horror, provokes their instinct to punish, or otherwise may cause a jury to base their decision on something other than the established propositions in this case. Moreover, in balancing, and that's the end of this. Okay, so moreover, in balancing the probative value of evidence against the risk of unfair prejudice, the fact that evidence goes to a central issue in the case tips the balance of favor of admission. And that's where it ends. So I think whoever uploaded this, cut off the last page, which probably just said, for these reasons, we believe you should allow us to talk about the federal investigation. So with that, David Yannetti submitted an affidavit in support of the motion in limine to allow evidence of lack of bias. So let's see what he has to say. I'm an attorney licensed to practice in Massachusetts since December 20th, 1989. My office address is Yannetti Criminal Defense Law Firm. Okay, we're not going to read that. On January 29th, 2022, I was retained to represent Karen Reed regarding the above captioned matter. Two witnesses from AARCA testified during the defense case during the first trial in this matter, Dr. Daniel Wolf, PhD, and Andrew Rentschler, PhD. The defense did not initially retain or involve those experts in this investigation. They were instead retained by the United States Attorney's Office for the District of Massachusetts as part of their probe into the investigation of the death of Officer John O'Keefe. Each of these expert witnesses performed their testing and analysis pursuant to the mandates and the request of the United States Attorney's Office. So we want to be very clear in our words and say all of their testing and analysis was done at the behest of the Attorney's Office. Why can't I talk? United States Attorney's Office. The defense had no input into the matter of testing or analysis they would be performing, nor what materials they would be allowed to consider. So, defense had no input regarding what to test, how to test, what kind of testing might be done. They had no input in turning over any kind of materials for the AARCA experts to review. Those were handed over by the United States Attorney's Office. So Karen can't be, prejudiced by, oh, well, they didn't give them all the materials like Lolly tried to do in the first trial. So prior to the first trial in this matter, as discussed at length during hearings on February 18th, 25th, and March 5th, the defense did not pay AARCA prior to their testimony. At the first trial of this matter, the defense was prohibited from mentioning the federal investigation into this matter at all. Consequently, the jury was not allowed to consider that the ARCA experts were not retained by the defense, were not instructed by the defense to perform testing, were not provided by the defense any materials to consider, and were not involved with the defense at all prior to the completion of their testing. So once they completed their testing, that's when the defense finally knew of them and reached out to them. But ARCA never, ARCA completed all their testing all at the behest of the United States Attorney's Office and had nothing to do with Karen Reed. She had no input. The inability of the defense to explain the origins of ARCA's involvement in this case led to juror confusion and prejudiced Ms. Reed. After the trial, jurors have come forward to express their confusion about ARCA's testimony. At least one surmised that ARCA must have been retained by Ms. Reed's car insurance company, which would lead to an inference of bias in favor of Ms. Reed's version of events. At least another postulated that the ARCA experts were fame seekers. Having heard about this high profile case, they wanted to insert themselves into the trial to gain positive publicity for themselves and ARCA, which ARCA doesn't need because they already do the military and the NHL and all sorts of big names. They are already their uh, clients. So they didn't need it. It is ironic and wrong in retrospect, in my view, that the court was seeking to have the jury avoid speculating about a federal investigation, but in doing so caused the jury to speculate about ARCA in a way that tended to diminish their credibility and therefore diminished their effectiveness for Ms. Reed. Wow, that's a great line there. It is ironic and wrong in retrospect, in my view, that the court allowed this in the first trial, that the court allowed for the jury not to speculate about the federal investigation. And in doing so, they speculated about who hired ARCA and thought it was fame seeking or insurance companies, which made it even worse. Made it even worse for Karen. And so with this, I don't think, uh, I don't know. She can deny it. She can always deny it because she's Bev. But this is a really strong argument. You've got two separate jurors saying two separate things about speculating how the ARCA witnesses came about in this case. And that's not how it should be. So, probing the bias or lack of bias of a witness, including an expert witness, is a constitutional right possessed by every criminal defendant. So, we're going into more federal rights being stripped away from Karen Reed. Robbing the jury of the truth of the origin of ARCA's involvement in this case robbed the jury the appropriate opportunity to give appropriate weight to the opinions of the ARCA experts. The testimony of these witnesses, based on their analysis and findings, corroborates the essence of Ms. Reed's defense. Officer O'Keefe's injuries are not consistent with being hit by her SUV, nor is the damage to Ms. Reed's SUV consistent with colliding with a pedestrian. Allowing these witnesses to explain that they were initially retained by the DOJ and not by the defense, an insurance company, or a rogue third party like Turtle Boy provides important context for their testimony. The Commonwealth is, of course, free to explore their allegations of bias during cross examination. Not stating who retained the ARCA experts to conduct their testing, however, keeps important context from the jurors and causes confusion. The defense is not seeking to mention the existence of a federal investigation when questioning these witnesses or during any other. So they're not seeking to mention the existence of a federal investigation. They just want to be able to say the feds hired ARCA. It shouldn't be denied. It really shouldn't, but who knows what mood Bev's going to be in. Accordingly, I believe it is in the interests of justice that this honorable court allows this motion in limine. signed under the pains of penalties of perjury. David Yannetti. I'm going to see if I can find the last page on there just in case we missed something. So hold on one second. Well, I'm glad I checked because we're missing several pages. So apologies on that. Let's get back to this the motion in Limine to allow them to talk about the ARCA being hired by the feds. So just read the affidavit by Yannetti. We're going back to the motion and we ended up here. All right, so here the fact that neutral third party experts hired by the U.S. Attorney's Office corroborate Ms. Reed's fundamental defense that Mr. O'Keefe's injuries are not consistent with being hit by her SUV, nor is the damage to her SUV consistent with colliding with Mr. O'Keefe, is inherently central and foundational to the fair adjudication of this case. Additionally, the Commonwealth has faced no unfair prejudice. The Commonwealth had the opportunity to cross-examine ARCA experts during voir dire in Ms. Reed's trial, and notably, the Commonwealth is privy to the testimony of ARCA employees in Ms. Reed's first trial. Additionally, the Commonwealth has access to the same discovery that the defense has received regarding these employees. Thus, there is no legitimate basis for the Commonwealth to even allege that providing information about the U.S. Attorney's Office hiring of ARCA would even be remotely prejudicial. So it's not going to prejudice the Commonwealth. They have access to the same data, same reports, same materials, same testimony. They have ability to cross-examine. This is not prejudicing the Commonwealth. The defense acknowledges that this is an unusual circumstance and, accordingly, an unusual motion in an unusual case. Generally, witnesses who are employed by the federal government testify on behalf of the Commonwealth, and defense counsel is unaware of any case in which a defendant has moved to preclude reference to the federal employer of a witness testifying on behalf of the Commonwealth. So, what he's saying here is there's no case that you can reference where a defendant had to ask that there was no mention of the fact that an expert was hired by a federal investigator. That's never happened. Usually, feds are, or expert witnesses for the feds are testifying for the state. So, the defendant can't just be like, well, let's not tell anybody that they were hired by the feds. It doesn't work that way. So, why does it work that way with the Commonwealth? Doesn't make any sense. It's double standards for sure. It is not uncommon for the Commonwealth to present witnesses employed by the federal government, especially, though not exclusively, in matters that involve a joint investigation by state and federal authorities. Discussing DNA testimony by a supervisory special agent and chemist for the FBI's DNA analysis unit during a motion hearing. Discussing DEA agent testimony elicited by the Commonwealth. Finding that references to a prior arrest of a defendant and an FBI fingerprint analysis were not elicited in bad faith, and holding that defendant was not prejudiced by those references. Undersigned counsel is unaware of any case in which a defendant has successfully argued that eliciting the fact that a witness was employed or contracted by the federal government was improper, let alone caused them prejudice. Ms. Reed suggests that the preclusion of any reference to the party that had retained ARCA during her first trial caused juror confusion and caused jurors to speculate about who had hired the company, prejudicing her defense by reducing the import of the testimony of perhaps her two most critical expert witnesses. I mean, yeah, you just undermined their testimony by not allowing the jurors to speculate who hired them. She knew what she was doing. She did that on purpose. I'm sure of it. Providing the jury with information about the underlying nature of ARCA's involvement surrounding Ms. Reed's case, furthermore, would certainly not cause undue delay, waste time, or be cumulative of other evidence. Such information could and would be elicited with a few questions during the direct examination of these potential witnesses, and by no means would asking the ARCA employees by whom they were hired and retained shall trial stall trial proceedings in a wasteful or cumulative way. So it's not going to waste time or be cumulative by asking who employed them. Questioning on this matter would be brief and could not be entered into evidence but through direct examination. Most importantly, perhaps, this pertinent evidence would not confuse the jury. In fact, clarifying how ARCA employees became involved in the investigation surrounding Ms. Reed's case would only mitigate potential jury confusion as discussed above. Relatedly, for example, in Ms. Reed's first trial, the defense asked during direct examination whether ARCA employees were hired by the defense or Commonwealth. The testifying witnesses, Dr. Wolf and Dr. Rentschler, both answered in the negative because further specific questioning about how these ARCA employees became involved in the investigation surrounding Ms. Reed's case is not permitted, though the jury was left to speculate, theorizing erroneously that the third party, such as Ms. Reed's car insurance company, was responsible for involving ARCA in this matter. Such an inference by the jury, even if logical, is patently inaccurate. Moreover, the jury should not have to resort to filling in unclear gaps by hypothesizing about the relationship between ARCA and Ms. Reed, as that allows for facts certainly not rooted in truth and in evidence to influence the jury's perception of key witnesses. This is beautifully written, David Yannetti. Good job. This speculation was not cured by the court's instructions to the jury during the first trial and is unlikely to be remedied by any instruction in Ms. Reed's retrial. The footnote here, it says function of the jury, what is evidence, credibility, witnesses, picture in your minds that all of the evidence, testimony, exhibits, stipulations, went into a box. The box is now closed. Your verdicts must be based on what is in the box, together with any reasonable inferences you choose to draw from it. So you're allowed to draw inferences, but when you're improperly drawing inferences, it could have easily been cured in trial, that's a problem. So simply providing the jury with accurate information about who involves the ARCA employees in this matter would eliminate juror confusion, and more importantly, would prevent jurors from speculating about what third party hired and retained these individuals. Ms. Reed has a constitutional right to present exculpatory evidence. The Commonwealth is seeking to prevent the defense from eliciting that ARCA was initially hired by the U.S. Attorney's Office, seeks to deny Ms. Reed her most basic and fundamental constitutional right. The right to present a defense is guaranteed by Article 12 of the Massachusetts Declaration of Rights. The fact that ARCA was hired to perform its testing and analysis by the United States Attorney's Office is manifestly exculpatory. Just the fact that the FBI or the feds did this was, it shows that this is exculpatory evidence. And this witness testimony undermines the central conceit of the Commonwealth's case. The Commonwealth cannot, in good faith, cite legal authority in support of its request for this honorable court to exclude exculpatory information about the hiring of the ARCA employees, perhaps the most exculpatory and critical defense witnesses in this case. So basically, the Commonwealth nor the court have any good reason to legally refrain or prevent the defense from going into this. So why it was allowed in the first trial, I have no idea. But this is a much better motion second time around about this. So Dr. Wolf and Dr. Rentschler specifically were hired by the United States Attorney's Office to conduct an independent inquiry into whether Mr. O'Keefe's into whether Mr. O'Keefe died because of a collision with Ms. Reed's SUV. Resoundingly, these expert witnesses answered in the negative. Mr. O'Keefe neither died as a result of a collision with Ms. Reed's SUV, nor did any damage to Ms. Reed's car result from colliding with Mr. O'Keefe. This conclusion, made by a neutral third party not engaged by the defense to perform this testing, affirms Ms. Reed's defense and could serve as the most reliable, relevant, and exculpatory evidence in her forthcoming retrial. Exclusion of this evidence would materially prejudice Ms. Reed's defense. The substantial rights of a party are adversely affected when relevant evidence is erroneously excluded. Although evidence can be excluded under Massachusetts law if there is a risk of unfair prejudice, which there is not, that substantially outweighs its probative value. Here, however, any prejudicial effect runs entirely in the opposite direction. To exclude this pertinent evidence about the U.S. Attorney's hiring of AARCA would result in the jury deliberating with needlessly incomplete information. So you're sending them in to the jury deliberation room on purpose without complete information. Maybe not on purpose, but with it's not necessary to send them in there without that information when it could easily be remedied in trial. Ms. Reed's likely most exculpatory witnesses, given that such individuals were hired without bias or undue influence by a third party as part of a federal investigation, would only serve to invite jury confusion and cause unfair prejudice to the defense, contrary to the rules of evidence and fundamental constitutional principles of a defendant's right to present exculpatory witnesses. As a reminder, Judge, it is Ms. Reed's constitutional right to put on her defense, and that includes saying who hired AARCA. More specifically, the fact that a neutral third party substantiates Ms. Reed's core defense and completely undermines the Commonwealth's theory of the case is inherently exculpatory. Considering Massachusetts precedent, it is permissible, particularly during closing argument, to disclose by whom an expert was retained. In fact, a plethora of Massachusetts and federal case law confirms as such. This is wonderful. That he's backing Canoni into a corner because he's coming with receipts. He's coming with the reasons why, and he's like, we need to say that they were hired by the feds, and there's no reason for you. There's no legal standing that you have to exclude the fact that the feds hired them. It's just unreal that she did it the first time, in my opinion. All right, the fact that the expert witness was retained by the defense would have been an appropriate subject of argument in the jury. The fact that Dr. Mezer was retained by the defense was an appropriate subject of argument to the jury. The jury must be informed of the exact nature of the contingency agreement. The defense counsel must be permitted to cross-examine the witness about the agreement, and the jury must be specifically instructed to weigh the witness's testimony with care. A prosecutor can address in a closing argument a witness's demeanor, motive for testifying, and believability, provided that such remarks are based on the evidence or fair inferences drawn from it and are not based on the prosecutor's personal beliefs. While a prosecutor may not vouch for the truthfulness of a witness's testimony, we consistently have held that where the credibility of a witness is an issue, counsel may argue from the evidence why a witness should be believed. Internal citations omitted. In essence, there is deeply rooted basis for both identifying the specific terms of the retention and hiring of an expert witness, and there is foundational support for commenting on why a witness's credibility and here neutrality should be trusted. If Karen had hired them, of course the Commonwealth would want that in. So what's the difference? If you reverse it and say Karen did hire them, Would that be fair for the Commonwealth to keep that out? No. So like conversely, the opposite is not fair. So why are you doing this to her? You're supposed to be the pinnacle of like the essence of fairness and justice, but that is not what Massachusetts court of law appears to be. So in essence, there is a deeply rooted basis. I read that, sorry. Finally, Ms. Reed's constitutional right to present exculpatory information includes asserting a Bowden defense. Both the Commonwealth and defense have long had access to ARCA employees' findings regarding the death of Mr. O'Keefe, which resoundingly point to an inadequate investigation and a third party culprit, given that ARCA employees have testified under oath that Mr. O'Keefe's death was not a result of the injuries from not a result of injuries from Ms. Reed's SUV. Since the Commonwealth had access to this information and did not properly inquire of or investigate other potential suspects, Ms. Reed must be able to present evidence that law enforcement failed to pursue other avenues. Defendants have the right to base their defense on the failure of police adequately to investigate a murder in order to raise the issue of reasonable doubt as the defendant's guilt is in the mind of the jury. A Bowden defense, as it has commonly come to be known, may focus on either the failure of police to conduct certain scientific tests or their failure to investigate leads concerning suspects other than the defendant. The failure of the police to investigate leads concerning another suspect is sufficient grounds for Bowden defense. As a result, Ms. Reed should be permitted to provide the pertinent information regarding the circumstances of ARCA's involvement in the case, which led to their ultimate conclusion that Ms. Reed was not responsible for Mr. O'Keefe's death because such information provided by a third party is crucial to bolstering her foundational defense that the police investigation in this matter was wholly inadequate and that authorities failed to investigate alternative suspects. Conclusion: for the above reasons, Ms. Reed respectfully requests that this honorable court grant this motion in limine. So I'm glad I went back and looked for that because we had missed a few pages there. Real quick, so all these motions in limine, I know we've got a bunch going on right now, but all of them are going to be argued, as a reminder, March 18th and 19th. We will be back in court. Ms. Reed will be back in court. That is Tuesday and Wednesday of next week. I just wanted to make sure the days. So Tuesday and Wednesday next week, back in court to argue all of these motions in limine that we are going through. We've got a series of these episodes that we're going to do. We're breaking them down topic by topic. And let me know what you guys think. Do you think Judge Bev is going to allow this time around? I mean, David Yannetti's, I remember reading something back during the pretrial hearings that David Yannetti or somebody had put together a motion to allow for the federal investigation. I believe it was a motion in limine, but I can't remember. And she denied it. Can't remember really her basis for it, but I don't remember. She didn't want anything coming in for the federal investigation or that the feds hired ARCA, which I think was the wrong call, obviously. So there you have it. Trial begins 20 days from today, and next week we will begin hearings for the motions in limine. Let me know in the comments below what you think Judge Bev is going to do, and I will talk to you guys later. Please hit the like button on your way out. Thank you so much for watching. Bye now.